The Public Readiness and Emergency Preparedness (PREP) Act protects federal, state, and tribal governments, private sector planners, healthcare providers, and others from liability associated with rapid dispensing of medications during a large-scale public health emergency.
How does the PREP Act protect me?
Will volunteers who help out at pods be protected from liability?
Where can I find the PREP Act declaration?
Will our business partners who operate closed pods be protected?
Are pharmacists who dispense prophylaxis covered if someone has a reaction to the medication?
The PREP Act was enacted to serve two different goals. One, to alleviate liability concerns associated with a number of activities, including manufacture, testing, design, development, distribution, administration of covered countermeasures, or the types of products that are covered by the statute's protections. The second is to provide a compensation program for individuals who may be injured as a result of taking those covered countermeasures. That program covers medical benefits, lost wages, and death benefits. The PREP Act defines covered countermeasures using a number of different statutory definitions. They're fairly complex, but basically they are devices, drugs, and biological products, such as those regulated by the Food and Drug Administration, that are licensed, cleared, or approved under an IND or under an emergency use authorization. A tort is generally understood within the legal field as a claim for loss that's recognized by the court system other than a breach of contract. Losses that are recognized by the statute include losses for death, physical, mental, or emotional injury, fear of such injury, or property loss, including business interruption. Any loss that's claimed in the PREP Act, though, must have a causal relationship to the manufacture, design, distribution, administration, use, etc. of the covered countermeasure itself. Under the PREP Act, protections are provided to covered persons. Covered persons are specifically defined in the statute to include manufacturers of countermeasures, distributors of countermeasures, program planners, qualified persons who prescribe or administer covered countermeasures, the United States. Declarations under the PREP Act are made by the Secretary of the Department of Health and Human Services. They're published in the Federal Register. The Secretary has issued a number of declarations under the PREP Act. These include smallpox countermeasures, anthrax countermeasures, influenza vaccine, including for H1N1, and pandemic influenza antivirals. In addition, the Secretary has made a declaration for certain respiratory devices. For a full list of declarations, see the HHS website. When the Secretary makes a declaration, the statute requires certain contents. These include a determination of a threat or credible risk, a recommendation for action, for example, manufacture, testing, use, etc., the category of diseases or health conditions or health threats that the declaration covers, the effective time period, which may be a set time period or may be based upon a triggering event, the receiving population, the geographic area of administration, any limitations, for example, in the geographic area or means of distribution, and additional qualified persons. The definition qualified person includes two different categories of individuals. First, it includes individuals who are licensed under state law to prescribe or administer a covered countermeasure, but it also includes a category of individuals that's specifically defined by the Secretary in a declaration. Included within those persons are volunteers as well as officials, agents, or employees of those who are involved in the medical or public health response. As long as the individual is authorized in accordance with a public health or medical response that is conducted by an authority having jurisdiction, then it would apply irrespective of whether or not those individuals are medical versus non-medical. The Secretary has also defined qualified persons in these declarations to include individuals who prescribe, administer, or use covered countermeasures in accordance with an emergency use authorization. So, for example, in many of the declarations, including the influenza antivirals declaration as well as the anthrax countermeasure declaration, there's specific language identifying these categories of additional qualified persons. State and local governments who carry out responsibilities in terms of mass dispensation of antibiotics are more than likely covered under the definition of program planner as defined in the Act. Program planners include not only state and local governments but also tribal governments, as well as other persons such as private entities, community groups, or business entities to the extent they carry out certain activities. Those activities include supervising or administering a program for administration of a covered countermeasure, providing technical or scientific guidance, or providing a facility for administration or use of a countermeasure. The PREP Act's protections are not limited to federal assets and may also apply to state and local assets. However, there are provisions in declarations that may limit the extent of these statutes' protections. I therefore would highly recommend that planners check with their lawyers and look closely at each declaration to determine whether or not any of those limitations apply. The PREP Act includes one specific limitation. It does not cover willful misconduct. So if an entity commits willful misconduct, actions against that entity would not be barred by the statute. There are a number of other limitations on the applicability of the Act. For example, actions that take place outside the scope of a declaration are not covered by the Act's protections. To give you an example, each declaration includes its geographic applicability as well as its effective time period. So if a claim arose outside that geographic area or outside the time period for which the declaration is effective, then a claim would not be barred under the PREP Act. Other limitations on the PREP Act's immunity provisions include claims that have no causal relationship to the administration or use of a countermeasure. In addition, claims brought in foreign courts likely would not be covered under the PREP Act's protections because foreign courts likely do not recognize U.S. law. Finally, claims for other than tort actions, for example, violations of labor laws, civil rights laws, the ADA, for example, are not precluded by the PREP Act. I understand a lot of states and locals are wondering whether the PREP Act preempts state dispensing laws, drug dispensing laws. The PREP Act is not a drug dispensing law, but a liability immunity law. And so therefore it doesn't override or preempt those types of laws. An emergency use authorization may, however, preempt those types of laws. In order for states and cities to ensure that they're covered by the PREP Act's protections, they should consult with their lawyers, read and understand the statute as well as each declaration that may be relevant, and ensure that their actions fall within the scope of those declarations.